Right, everybody. I hope you can hear me and see me. I guess chime into the chat if you're having problems seeing or hearing me. But I'm assuming we are good to go. So we'll go ahead and get started. My name is Brian Peterson. I'm an attorney here at Hansen Johnson. And one of the areas that I practice in is employment law. And so what we're going to be doing today is I'll be going through a number of the provisions that came out in the two recent federal government stimulus bills, the Families First Coronavirus Response Act and the Coronavirus Aid, Relief, and Economic Security Act, or the CARES Act. So I'll be going through some provisions that deal with employees, basically the employment provisions. So provisions that your employees may be trying to take and the impacts that it will have on you as an employer. Quick disclaimer before I get going. This presentation is for information purposes only. It's not meant to address any specific situation, and it's not meant to be legal advice, and it does not result in an attorney-client relationship with Hansen Johnson. So let me first talk about, what I'm going to do. I'm going to go through this presentation, and then I'll have some time for questions at the end. And so if I'm not able to keep up on the chat questions as they come through, we'll go through those at the end. First off, I want to talk about a couple provisions from the Families First Coronavirus Response Act that is effective April 1, 2020 and ends December 31st, 2020. The first part I want to talk about is what I'm calling emergency family medical leave. You are probably familiar with the federal law, Family and Medical Leave Act, or FMLA. So there's a provision that expands this FMLA, and I'm calling it emergency FMLA. And what it deals with is under this FMLA law, if you remember, employees could take up to 12 weeks of unpaid leave if they had a situation come up such as childbirth, caring for an immediate family member with a serious health condition, or if the employee himself had a serious health condition. The employer can't fire the employee for taking this leave and has to have his job available for him when he comes back. So under this federal stimulus act that recently came out, it expands this family medical leave. And what it does is it allows an employee to take this family medical leave for up to 12 weeks and get paid during that leave. So here's what employers does this apply to? This applies to any employer with fewer than 500 employees. So here's the provisions. An employee gets to take up to 12 weeks of paid emergency FMLA leave if the leave is taken between April 1, 2020 and December 31st, 2020. And if the employee is unable to work or unable to telework and has to take leave because he has to care for his child who's under the age of 18, if the child's school or daycare setup has been closed due to COVID-19. So another provision of this is the employee has to get his job back at the previous pay and benefits that he had before, or get him in a similar job that has equivalent pay and benefits as he had before. What employees are eligible for this? So this stimulus act amended which employees are eligible. Now it's any employee that has been employed for at least 30 days before he took the leave. Are there any excluded employees? I'll talk about a couple things with this. One, the Secretary of Labor can issue regulations that that allow the exclusion of certain healthcare providers and emergency responders to not be an eligible employee that can take this leave. I've checked and I can't find that there's any regulations out yet. How much does this employee get paid and when? So the first 10 days of this leave may be unpaid leave. That's the general rule. But the employee can decide to use 2 weeks of his already accrued paid leave that he have. Maybe he has vacation, or your employer that does paid sick leave. The employer or the employee can substitute that for the first 10 days of unpaid leave. Or what the employee can do is there's another provision from this stimulus package, which I'll talk about in a minute, but it deals with emergency paid leave. And the employee can take up to 2 weeks or 80 hours of this emergency paid leave and have it substitute for these first 10 days in which the employee does not get paid leave under this emergency FMLA leave. Now, how much does the employee get paid? The employee gets paid 2/3 of his normal pay at the number of hours that he usually worked. But this is capped at $200 per day and $10,000 in the aggregate per employee. So are there situations where the employer does not have to hire this employee back? Yes, the employer does not have to hire the employee back if the employer employs fewer than 25 employees and the position that the employee had before he left no longer exists when he returns due to changes in conditions at the employer, changes in their operating conditions, and changes in their economic or financial health that affected employment. And these changes in economic conditions at the employer are caused by a public health emergency that occurred during the leave. We are in a public health emergency right now. The employer also has to make reasonable efforts to restore the employee to his job that he had before, and if those reasonable efforts fail, then the employer has to make reasonable efforts to give this employee notice within 1 year if another position becomes available that's comparable to what the employee had before. Now, how many times can this employee take this emergency FMLA leave? Meaning, can the employee leave for 12 weeks, come back, work for another few weeks, and then take leave again? The answer is no. And each employee only gets one session of leave up to 12 weeks within a 1-year period. Can the employee take intermittent leave? So meaning the employee can take 12 weeks total, but can the employee take 3 weeks off, come back and work a week, take another 3 weeks off? The answer is yes, if the employer and employee agree to such an arrangement. What does the employer or what does the employee need to do to begin these benefits? There's no real formal procedure, but the employee should make a formal request to the employer requesting this emergency FMLA leave. And the employee should be able to articulate why he needs to take this leave and why he qualifies, meaning that he has a child at home that he has to care for, whose school or daycare system has been closed due to COVID-19. Now, there's some provisions for the employers here in order to be able to pay for this, because you're probably thinking as an employer, wow, I've got to pay up to 12 weeks of leave. How am I going to do that with no production from the employee? So the stimulus bills included these provisions for the employer. One, the employer gets a tax credit dollar for dollar for the amount of leave wages that are paid to the employee. So again, a tax credit means it's a dollar for dollar decrease on the employer's taxable obligation or taxes owed for each dollar that he pays to the employee in this leave. Now, but remember, the tax credit is only up to the limits, meaning $200 per day for the employee or $10,000 in the aggregate. The employer can take this tax credit on its quarterly tax return, so it doesn't have to wait for some type of annual return, but it can do the quarterly tax filing and take this credit for the leave that the employee had during that quarter. Next, the employer gets a tax credit for any employer contributions to premiums for the employer's group health plan. One provision of the FMLA Act is that the employer has to keep this employee on the employer's group health plan while the employee's out. And so that may, if there was a cost sharing setup where the employer paid a certain percentage of the premiums, the employee pays a certain percentage of the premiums, the employer has to pay that percentage of the premiums while the employee's out, and the employer gets a tax credit for that. Now the employee will have to still pay his portion of the premiums, and the employer can make that up from paychecks when the employee comes back. The next benefit the employer gets is these leave wages. The employer does not have to pay FICA, meaning Medicare and Social Security taxes on these leave wages. So that is a benefit as well. Now, are there any exemptions? I talked before about that the Secretary of Labor can issue regulations allowing employers to be exempt from this if the employer by having to pay this leave, if that would jeopardize the employer's viability as a going concern. Now, that if the secretary does release those such regulations, that's only going to apply to employers that have 50 or fewer employees. Well, actually fewer than 50. Again, no details yet about regulations on employers being able to apply for this exemption. Another possibility here is that oddly in this stimulus bill, it says that the secretary can issue regulations allowing employers to not have to allow this leave for if the employer has employees that are emergency responders or in the healthcare field. But on the other hand, this act also has an explicit provision that says employers who are in the healthcare field, who have employees that provide health services or healthcare to people or are emergency responders can be, and the employer can specifically exclude those employees from taking this leave. So it is kind of an odd deal in the act, but really employers that employ healthcare providers or emergency responders are able to exclude such employees from this leave if they desire. Okay, so moving on, I want to talk about the next provision under these stimulus bills, and this deals with emergency paid sick leave. So this is different than family medical leave. This is actually this is just paid sick leave. And I'm calling this emergency paid sick leave. And this provision applies also to employers with fewer than 500 employees. So what are the benefits? These are provisions for employees. The employer must provide each employee paid sick leave if the employee is unable to work and needs to take leave because one of the reasons that I'm going to state here. The employee is subject to federal, state, or local quarantine or isolation order due to COVID-19. the employee's been told by a healthcare provider that he needs to self-quarantine because of COVID-19 concerns. The employee has symptoms of COVID-19 and he's seeking a medical diagnosis. The employee is caring for an individual, one of those individuals that I just talked about, or the employee is caring for a son or daughter whose school or daycare has been closed due to COVID-19. Or the employee is experiencing similar conditions that the Secretary of Health and Human Services will put out in future regulations. So what is the duration of this paid sick leave if the employee needs to take it? Full-time employees get to take up to 80 hours of paid sick leave. And part-time employees will get to take the number of hours that the employee worked, basically the average number of hours the employee worked over a 2-week period. You know, what's that average? That's generally the number of hours that a part-time employee would get to take in paid sick leave. So how much does the employee get paid if he has to take this sick leave? Well, the employee gets his full normal wages, so as if he didn't take the leave. But this is capped, and it's capped depending on the reason for the leave. Now, if you have an employee that has to take the leave because the employee has symptoms of COVID-19, or he's required to quarantine or isolate due to a federal, state, or a local quarantine order, or a healthcare provider tells him to quarantine or isolate, he gets up to, the cap on that is up to $511 per day. So he gets paid his normal wages up to $511 per day, or $5,100 in the aggregate for those 80 hours of leave. So that's the cap. But again, he gets paid his normal pay, but again, that normal pay is just capped at those amounts that I talked about. Now, if the employee has to take leave because one of the other reasons that I talked about, for example, if he has to take leave due to caring for a person that is under quarantine, or caring for his child whose school or daycare is closed because of COVID-19, in that situation, the employee gets paid leave, but it's only 2/3 of his normal pay. And he can take it up to these limits, up to $200 per day and $2,000 in the aggregate for the whole period of leave. Now, on this, well, actually, I'm going to go on. Who is eligible for this leave? Any employee actually that's been employed for any amount of time is eligible for this leave. Also, the employer can require the employee, after the employee takes his first day of leave, the employer can require that employee to give kind of intermittent notices to the employer that he still has a need for leave. The employer can require the employee to take to provide some documentation, maybe some doctor's documentation that he still has a need for this leave. I want to circle back real quick on this emergency family medical leave. Again, it's up to 80 hours of leave. Now, if you remember in the emergency family medical leave that I talked about, that's where the employee can take up to 12 weeks of paid leave. And you remember I said that the first 10 days of that leave are unpaid. So what the stimulus bills allow is that for those first 10 days that are unpaid under the emergency family medical leave, the employee could actually take this emergency paid sick leave and use up to 80 hours to cover those first 10 days of emergency family medical leave. Again, the question on this is, on this emergency paid leave, can an employee go ahead and take up to 80 hours of emergency paid leave, come back and work, and then, oh, another emergency comes up, and take another 80 hours? The answer is no. The employee only gets one session of this emergency paid leave if the leave is taken anytime from basically April 1 up through December 31st, 2020. Are there any exemptions? Yes, from this paid leave. Again, and if an employer employs healthcare workers or emergency responder workers, the employer can elect not to allow this leave. If the employer has more than 500 employees, if you're a little larger employer, this act does not apply to you. And also, the Secretary of Labor, again, may issue regulations allowing businesses with fewer than 50 employees to be exempt from the employer having to do this emergency paid sick leave. Again, there is no regulations yet. Does the employee taking the leave have to find a replacement employee to cover his spot while on leave? No. Can the employer require the employee to use other paid leave before he uses this emergency paid sick leave? And the answer is no on that as well. So what are the duties of the employer with this emergency paid sick leave? Well, provide the paid sick leave if the employee qualifies and requests it. The employer also has to post notice of the availability of this emergent sick leave, generally along with your other labor notices that are often placed in break rooms, that sort of place at your office. Second, don't fire, discipline, or retaliate or discriminate against an employee that takes this leave. Also, don't do the same thing against an employee that takes the emergency FMLA leave either. So what are the benefits for the employer here? The same as above, the same tax credits that I talked about for the emergency FMLA leave applies here as well. Dollar for dollar tax credit up to the paid leave limits that I talked about. Again, credit for any employer portion of the premiums going to paid to the healthcare plan, and also the employer doesn't have to pay childcare taxes on this leave. Moving on here, I want to talk about the stimulus bills that flew as a couple of healthcare provisions so group health plans, first group health plans and insurance that a person may get on the market exchange has to fully cover COVID-19 or SARS diagnostic testing, meaning they have to fully cover that at no cost to the employee. No cost sharing, no deductibles, no co-payments. Also, the same group health plans and an insurance plan that a person gets on the market exchange, they have to cover as preventive services any diagnostic tests or any type of preventive item or procedure that helps prevent COVID-19. And this can mean diagnostic tests, immunizations when such becomes available. Those types of things that are used to prevent COVID-19 have to be covered as a preventive service under the Affordable Care Act. And the benefit of that is preventive services under the Affordable Care Act have to be fully covered without co-pays, deductibles, and cost sharing. Okay. I know I'm moving quick here, but we're going to move through to some provisions of the Coronavirus Aid, Relief, and Economic Security Act now, or the CARES Act. If I get time at the end, I'll quickly talk about the tax rebates that are available to individuals. I summarized those in a handout that I sent out to everybody earlier. If I get time, I'll go over those. But I want to start with basically a few provisions about retirement plans that come from the CARES Act.
Brian, before you move into retirement plans, there's a couple of questions on the group chat about that paid sick leave.
Okay, why don't I pull that up? Let me see if I can pull up this chat here without messing this up. On the paid sick leave, question is, what if the employee had to quarantine before April 1? Is the emergency paid sick leave still in effect? There's no retroactivity on this emergency paid sick leave. The effective dates are essentially the effective dates of the act, April 1 through December 31st, 2020. So there's a chance, so in the actual language of the law, there's no retroactivity, meaning before April 1. There's a chance in regulations that the Secretary of Labor comes out with such provision. Next question is, so if it's a very small business, fewer than 50 employees, then both these employee leave options are valid. Yes, the issue with it being a smaller business is if there's fewer than 50 employees, the Secretary of Labor may put out regulations that allow employers with fewer than 50 employees to basically register for a hardship exemption, in which they have to basically articulate that giving employees or having to pay this type of leave for employees would cause such financial distress on the employer that it could put them in danger of being a going concern. So I think that takes care of the two chat questions that were out there. Let me move on to the retirement provisions now in the CARES Act. First off, just a few retirement provisions in the CARES Act. One on distributions. There's no 10% early distribution penalty on distributions that are taken during 2020 if the distribution is taken for a COVID-19 reason. There's a few other conditions that I believe I put in the handout. I won't go over those now. Moving on to loans. If an employee wants to take a loan from your retirement plan or his IRA, if you as an employer have the availability of plan loans, the employee can take such a loan. And here's some of the benefits or the changes. If he takes a loan within 180 days of enactment, basically 180 days of April 1, 2020, and the loan amount changes from what he could take before. He can take a loan up to the lesser of these numbers. It can be, if it's up to $100,000, or the full vested benefit in his account. Now that's a change to what it was before. Before this amendment, the employee could only take a loan up to $100,000 and half of his vested benefit, whichever was less. Another provision for retirement plan loans is if the employee has an outstanding loan already, and a payment is coming due between basically April 1, 2020 and December 31st, 2020, if a loan payment is coming due, that employee can choose to delay paying that loan payment for 1 year. Moving on, I want to talk about, under the CARES Act now, some unemployment provisions, because certainly employees and you as employers will probably want to know about these. The first unemployment provision that I want to talk about deals with unemployment benefits for people who can qualify for state unemployment. These unemployment provisions, they apply to any employer. So this applies to all employers, no matter how many employees you have. And again, these provisions that I'm going to talk about deal with employees who could qualify under state unemployment. So what does the employee get? In addition to what the employee would get under the normal state unemployment regime, so meaning if the employee qualifies for state unemployment and he goes on unemployment, he gets the normal state benefits plus an additional $600 per week that comes from this CARES stimulus bill. There's kind of an oddity with this $600 per week. The stimulus bill itself says that this $600 per week only goes for unemployment payments that are made up through July 31st of 2020. But on the other hand, there's explicit language in this CARES Act for this portion of the unemployment benefits that says, well, once an employee has exhausted all his unemployment benefits through the state, then the federal government will fund an additional 13 weeks of unemployment pay at the normal rate that the employee would have received under the state unemployment regime, plus the additional $600. So it's kind of an odd thing in the language. It's almost as if the government allows the extra $600 through July 31st, but then if the time comes that the employee has exhausted all his benefits under the state unemployment, then the federal government will extend those benefits another 13 weeks at his normal rate plus the additional $600. What are the requirements to get this unemployment? Well, the way this works is the state of Idaho or the corresponding state has to enter into an agreement to provide these benefits with the Secretary of Labor, the U.S. Secretary of Labor. So that has to happen first. And then obviously the employee must qualify under state unemployment to be able to get these benefits. The employee has to be available to work and be actively seeking work as well. The dates on this, well, in fact, I'll skip that because I've already covered really the dates on this. The dates for the additional, well, I will say the effective dates for the additional 13 weeks they go through December 31st, 2020. So these unemployment benefits that I'm talking about only extend through December 31st, 2020. The next unemployment provision that I want to talk about is a benefit for people that cannot qualify under the state unemployment benefit regime. They may not be able to qualify because one, they've exhausted all their state benefits, or two, they haven't been laid off yet. Generally, a requirement under state unemployment is you have to be laid off. So maybe they don't qualify for those reasons. So the federal government wanted to help people out that they can't qualify under state unemployment. They didn't want to leave those people behind. Again, that's the first requirement for a person to get unemployment benefits under this provision of the CARES Act. And this provision is called the Pandemic Unemployment Assistance Program. So to get unemployment under this program, one, you have to not be able to qualify under the state unemployment regime, but you have to be available to work. You could work, but you just can't qualify for unemployment. This person has to be unemployed or partially unemployed because of a COVID-19 reason, which I'll explain what those reasons are in a minute, or the person has to be unavailable or unable to work because of a COVID-19 reason. The COVID-19 reasons are this: the person has COVID-19 symptoms, or someone in his household does, or he has a kid, or a kid whose school or daycare is closed because of COVID-19. The person can't get to work, can't get to his employer because of COVID-19 isolation orders, or the employer is closed because of an isolation order, or the employee had to quit because of COVID-19. This unemployment provision, these unemployment benefits, they're not for people who can do paid telework. Or who are receiving paid sick leave or emergency FMLA leave. So again, these unemployment provisions are for people who can't qualify for state unemployment, and they can't work, or they're unemployed or partially unemployed or can't work because of a COVID-19 reason. So what does this unemployment benefit grant? Basically, it grants the person their normal unemployment benefits that they would get under the state regime. So they have to qualify for those. And they get, again, the additional $600 per week that I talked about before. Again, and then the time period on this one goes up to, the law allows the time period on this, or the unemployment benefits, to go up to 39 weeks, as long as the employee or the person continues to qualify for those unemployment benefits each week. There is no waiting period on this unemployment benefit, and that goes with the previous unemployment benefit I talked about as well. Usually under state unemployment benefit regimes, Idaho included, they don't pay the person unemployment benefits for the first week that they're on unemployment. But these federal this federal stimulus bill, the CARES Act, pays for that first week when the state wouldn't normally. What is the process to get this unpaid, or this unemployment benefit? Basically, with both of these unemployment benefits that I've talked about, the person has to apply through their state unemployment regime. And in the handout, I included several links to the Idaho Department of Labor unemployment website. Again, on this unemployment provision, the Secretary of Labor has to form an agreement with the state of Idaho in order to make these provisions effective. What I will say is that I haven't found any information. I've looked, I can't find any information that verifies whether the state of Idaho has formed such an agreement with the U.S. Secretary of Labor yet. What are the effective dates for this unemployment benefit? And again, I'm talking about the unemployment benefit for an employee that, or for a person that can't qualify under state unemployment and they can't work or they're unemployed because of a COVID-19 reason. This one actually does have a retroactive effect. The person can get unemployment benefits beginning on or after January 27th, 2020 and ending on or before December 31st, 2020. So there's a retroactive benefit here. Here's another practical consideration. Well, basically some practical considerations for these unemployment benefits. One is we have to wait for the state of Idaho to form an agreement to make all this happen. Has to form an agreement with the U.S. Secretary of Labor. The Labor Department has to transmit all the money to the state, and basically estimated amounts that it thinks the state is going to need, which will, of course, be replenished over time. Then there's also, I checked on the Idaho Department of Labor's unemployment website just yesterday, and they have a note there that says, expect delays in processing unemployment applications. And I think we can understand that because obviously they're having a deluge of unemployment applications coming in. So those are some practical considerations you'll want to take. I'll go ahead and answer a couple of these chat questions here. Let me pull these up. The first question is, how does unemployment work for Schedule C sole proprietors, as they don't technically issue paychecks from their Schedule C business, deeming them not eligible for traditional state unemployment? Or do you file for pandemic unemployment assistance? Confusing as to Schedule C. Let me just verify in my notes real quick. But if I remember right, these unemployment benefits are for, I think I have it in my notes here. 1 second. I can't find it in my notes. I may have to email you. I know I have it in my notes. I just can't find it quickly. But I'm pretty sure that there was a provision allowing these unemployment benefits to go to those who are self-employed, independent contractors. So I think that these provisions didn't want to leave those people out. I may have to try and get your contact information and email you. I know it's in my notes. I just can't quickly find it right now. And that looks like that's what the second chat question was about as well. I think I've gone about 43 minutes. A lot of material covered here. For any of those that are patient, I can take some questions now. I just have to figure out how I can hear your question. Does anybody have any questions? Looks like I might have another. Okay. Are there any provisions? Let's see. Any provisions for K-1 income, partnership? The answer, I do not know for that. I may have to get some clarification from you as well, a little bit more what you mean there, send me your email address on the K1 question, and I'll get some clarification from you. Let's see, go down the list here. All right, I think mostly people have just asked questions kind of on the independent contractor and to email them. I've got the question on the K1 income as well. So I will take down your email address and get that to you. Anybody else have any questions they might want to pose through the chat? Give you another couple minutes. If not, basically put your question out through the chat, and I'll include your email address, and I will get back to you. But otherwise, I appreciate your time. I know this took long. I know it was fast. If anybody didn't get the handout, I can email that to you as well. Anyway, thank you so much. Again, Anxman Johnson, we are here for your employment needs. If you have any employment matters that come up, we'll be happy to help you out. Contact us, and anyway, take care and best of luck pushing through this difficult time.